recently passed three labor codes, namely Occupational Safety, Health and Working Conditions Code 2020, the Industrial Relations Code 2020, and the Code on Social Security 2020. These three codes have also received the presidential assent on September 28th of this year. The Code on Wages was passed in 2019, and the same has also received the presidential assent. The labor codes consolidate and amend 29 central labor laws. The introduction of the labor codes is being looked as a historic overhauling of the current labor law regime and an instrument to facilitate ease of doing business in India. Today's session will provide an analysis of the salient features of the Occupational Health, Safety and Working Conditions Code, the Industrial Relations Code, and the Code on Social Security, with a view to help the industry navigate through the key changes being introduced by the way of labor codes. We are fortunate to have with us our guest speakers who will provide guidance on the current status of these labor codes, common definitions and concepts across the labor code, key differences between new labor codes and the existing laws, and its impact on the ease of doing business will also be discussed. A brief about FGI. Federation of Gujarat Industries was founded in the year 1918 in the erstwhile Baroda state under the progressive rule of Srimant Sayajirao Gaikwad III. It is an apex industries association and a recognized chamber of commerce in Gujarat, having an illustrious track record of over 100 years in the service of trade and industry. FGI has grown from strength to strength and has blossomed into a mature industries association providing guidance, hand-holding the industries of our state, ably representing the pain areas faced by the industries to all relevant authorities in the state and central government. FGI has also actively, timely provided representations, suggestions, and feedback to the state and central government on issues related to taxation, policy matters, and foreign trade, etc. FGI's success over the years is the result of the commendable support of our past presidents, members of the managing committee, our esteemed FGI members, consultants, and our FGI secretariat. Before I conclude, I would like to reaffirm FGI's commitment to steer the growth of its member industries, and we shall continue working closely with the government for due implementation of policies and initiatives. I thank you all for your attention. I now invite Ms. Mohanty to share her thoughts and take this webinar forward. Thank you.
Thank you for the very kind introduction, sir. I'm just going to take a minute to upload our presentation.
Richard, I'll do that here.
Yeah, thank you, Abe. So good afternoon, everybody, and welcome to this special session on decoding the labor codes. I've had the privilege of being closely associated with FGI for a while now, and I'm very pleased to be associated with the same. I will just take a minute to introduce our law firm to you. I'm a partner with Cyril Amarchand Mangaldas, and I specialize in labor and employment laws. Cyril Amarchand Mangaldas, also known as CAM, is a leading full-service law firm in the country with presence in over 6 cities. We also have a very robust and flourishing employment practice with over 3 dedicated partners and a team of almost 25 dedicated associates who kind of work exclusively on labor and employment matters across the length and the breadth of the country. As mentioned in the introduction, today's session will be conducted jointly by me and my esteemed colleague, Mr. Abe Ibrahim, who is also a partner at the firm. And now, before we dive into the presentation, I would just like to set some context of where we are today when it comes to the legal and regulatory landscape of employment laws in India. As you're aware, India is not an easy jurisdiction to maneuver, when it comes to labor law compliances. And this is primarily on account of the fact that both the central government as well as the state governments have been empowered under the Indian Constitution to be able to legislate on employment and labor matters. And as a result of this, we today have a multitude of labor legislations across the country, with close to 35 central laws and over 100 state laws. So as you can imagine, this is a Herculean task for any employer to be able to fully comply with all the requirements of the law, and while simultaneously looking at a profitable business. So it has been a constant ask, a long-standing demand from the industry over the years, that the labor law regime needs to be simplified, rationalized, with a view to aid with the compliance aspects of it. Now, given the construct of the labor codes, it would be right, introduced by the president, to say that the labor codes are in many ways historic, and it is definitely an attempt to kind of overhaul the entire regime. While there are several commonalities with the existing framework, there are a lot of new novel concepts, unique concepts that have been introduced in the labor codes, which we would be very happy to discuss with you shortly. I do perceive that at the beginning, when these labor codes do get notified and see the light of the day, we anticipate that there will be certain interpretational issues, some teething issues while we ease into the new labor codes. But overall, the intention of the legislator seems to be very clear. That is to maintain some sort of uniformity across laws in various parts of the country, increasing the coverage, which is to kind of include more and more people within the realm of the labor laws, especially with the view to include more of the unorganized sector within the fold, and of course, to aid with the ease of doing business in India. So in this session, we will cover the salient features of the three labor codes, the IR code, the SS code, as well as the OSH code. The wage code was covered in a previous session, so we will not go too deep into the wage code in particular, but we'll be happy to take any questions on it at the end. The presentation will be conducted in two parts. The first part will be done by me, where I will take you through the common definitions and some of the unique concepts across the code. And then I will also cover the industrial relations code in a little bit more detail, followed by Abe, who will cover the OSH code and the SS code and the salient features of the same. There is a lot to cover, and we hope that we can do this in the next 1 hour and 40 minutes or so that we can have effective Q&A session for about 20 minutes at the end. We request you to kindly type in all your questions in the Q&A box, and we will try our best to address as many as possible at the end of the session. So with that, very quickly, let me introduce to you the three labor codes that we are going to cover in the session today. The OSH code, the IR code, and the SS code are the three main codes that we are going to cover. Yeah, next slide, please. Yes. So a very brief intro on the status of the labor codes, something that you may already be aware of. Now, out of the 4 labor codes, the first one that was passed was the wage code. It happened about a year back, passed by the parliament, received the presidential assent. In fact, 2 rounds of the central draft rules had also been released for stakeholder comments. And now we are awaiting the date of notification for the wage code. The SS code, OSH code, and IR code, as you're all aware, has been recently passed by the parliament, and it has already received the presidential assent. Draft rules are being sort of put together as we speak. The draft rules for the IR code have just been released for stakeholder comments, and the draft rules for the other 2 codes, the SS and the OSH code, are currently awaited. If newspaper reports are to be believed, the government seems to be ready to roll out these codes as early as April 2021. But of course, that would be subject to them being able to, release the draft rules on time. They're also, I think, working in collaboration with the state governments and trying to ensure that the state governments also subsequently release the draft rules that would be applicable to industries and sectors that come within the fold of the jurisdiction of the state governments. So we are still awaiting the date of notification of all these codes, though they are ready to sort of see the light of the day. We are awaiting the date of notifications for all 4 of the labor codes. So till such time, the current regime, all these 29 laws that are proposed to be subsumed by the labor codes, continue to exist in their current form. And will continue to do so till the time that the labor codes come into effect. It is also possible that these codes may be sort of brought into force in a staggered manner, where maybe a few chapters of a code or perhaps 1 or 2 codes could be brought into force earlier than the others. And we'll just have to wait and watch how that goes. Next slide, please. So very quickly, let's look at the laws that are proposed to be subsumed by each of these 3 labor codes. Now, the IR code subsumes 3 laws: the Industrial Disputes Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. Next, please. Yeah, the laws subsumed by the OSH code. Again, there are about 13 laws. And as you can see, a lot of industry specific laws are also proposed to be subsumed. In the presentation today, we are going to be touching upon the key sort of central statutes and talking about the salient features of some of them. Next slide, please. Yeah, and the laws subsumed by the SS code, again, there are about 9 of them: EPF Act, ESIC Act, Employee Compensation Gratuity, BOCWSS Act, Maternity Act, Employment Exchanges Act, Unorganized Workers Social Security Act, and the Cine Workers Welfare Fund Act. Thank you. So with this, I move on to a very interesting section, where we are going to be talking to you about really the uniformity of definitions across these codes. So I think, is this something that we're all aware of, that, currently the biggest issue with the current framework of labor laws is that there's a lot of inconsistency between the definitions across different statutes. So for example, the wage definition, say under the EPF Act, would differ from that of, say, a payment of bonus act, and so on and so forth. So it becomes extremely difficult for an employer to be able to even pinpoint as to what act applies to him, whether the central act applies, a state act applies, do I fall within the threshold of it? Does the industry apply to me? So there are a lot of these questions that come about, and there's a lot of course confusion in terms of how this will play out to a employer. And keeping in mind the challenges that all these multiple definitions pose, one of the striking, most important features of all these labor codes is that there's a genuine attempt to try and to unify the definitions and to come up with the uniform definitions of key terminology across these codes. Now, these definitions are not exactly the same, but they are substantially, to a great extent, very similar to each other as used in each of these codes. So I'll quickly take you through some of the key definitions here. Now, the wage definition is, of course, a very important definition, not just from the point of view of the wage code, but it's a similar definition that is used in the other codes as well. Now, it includes, and I quote, all remuneration by way of salaries expressed in monetary terms, which includes basic wages, dearness allowance, and retaining allowance. This also has a very specific list of exclusions, which include components such as statutory bonus, PF, house rent allowance, value of house accommodation, etc. As you can see, the scope of the definition has been widened. Exclusions are specifically mentioned, and the general way to interpret it would be is that if an allowance is not specifically mentioned in the exclusion, then it would be subsumed within the definition of wages. One important concept that has been introduced is the proviso, the exclusion rule. So as per that, if the aggregate amount of the exclusions exceed 50% of the total remuneration payable to the employee, the amount in excess of 50% or such other percentage as may be notified by the government will be deemed to be remuneration and be added to the wages. So just to give you an example, next slide, please. If you have basic salary of say 5,000 and you have stat bonus of 3,000, conveyance allowance of 3,000 and overtime of 3,000, your total salary is 14,000. Now, if I were to just add up the exclusions, that is the circles which are indicated in orange, you will see that the aggregate amount of this comes to 9,000. Now, half 50% of your total salary, which is 14,000 here, would be 7,000. So to that extent, the total of the excluded components exceeds 50% of the total wage by 2,000 rupees. And therefore, as per the definition, in addition to basic salary, which is an included component, you will also have to include 2,000, which is the part which exceeds 50%, and therefore, for the purposes of computation, your wage will be 7,000 rupees. Moving on. Next slide, please. Next, we will focus on the definition of the employer. Now, if you see this employer again, it's an expanded inclusive definition, and now specifically includes contractors and legal representatives of the deceased employer. The definition also clarifies that the head of department, occupier, manager of the factory, or person having ultimate control over the affairs of the establishment are all covered within the ambit of the term employer. Next, again, the definition of contractor has also undergone a substantial change. Now, if you see, the emphasis really on a contractor, from a perspective of a contractor, is on the supply of manpower. The definition includes a person who undertakes to produce a given result for an establishment, not supply of goods or articles manufactured through contract labor, or a person who supplies contract labor as mere human resource and includes a subcontractor. So while the CLRA did not really distinguish between regular employees and those who were hired by the contractor for the work of the establishment, the definition of the IR code is quite clear. And it says that now the definition contract labor specifically excludes those who are in the regular employment of the contractor and receive increments, social security coverage, welfare benefits from the definition of contract labor. Now, this has been actually a long-standing demand of the industry, which is to differentiate outsourcing services, which is a service contract versus a mere manpower supply arrangement. The clarification in this definition of contractor is beneficial for principal employers to ensure that they are not always made liable for the defaults of another employer, mainly because the latter provides them services with the assistance of their regular workforce. Abe, in his section on OSH, will cover this in greater detail because the OSH subsumes the Contract Labor Act. So we'll cover a little bit more. We'll dive a little deeper into this concept at that stage. Pertinent to note that the IR code does not define the term contractor, but uses the term including in the definition of the term employer. Moving on. Definition of an employee. So there is a common definition of employee across all the labor codes, except when it comes to the Social Security Code. Now, the employee definition is quite widely worded, and it includes any person employed on wages by an establishment to do any skilled, semi-skilled, or unskilled manual, operational, supervisory, managerial, administrative, technical, or clerical work for hire or reward, as well as those persons declared to be an employee by the appropriate government. Key thing to note is that they actually also include supervisory, managerial, administrative persons. So it's a very broad concept. The concept of a worker or workman as such would actually be a subset of the definition of the term employee. We'll go into the worker definition when we discuss the IR code. This specifically excludes apprentices under Apprentices Act, this definition of employee, or any member of the armed forces of the union. Now, for the purposes of PF and ESIC benefits under the SS code, wage ceilings for employees to be covered under the SS code will be prescribed by the central government. For the purposes of employees' compensation, employee refers to such persons who are specified in the second schedule of the SS code, and the appropriate government can only make addition to the second schedule by way of amendment and cannot remove any categories of employees. Moving on, the next important definition is definition of appropriate government. Next slide, please. Thank you. So the definition of appropriate government is almost uniform across the board. The appropriate government for any industry controlled by the central government, or as notified in this regard, or for any specified industries in each of the codes, such as railways, mines, oil fields, major ports, etc., is the central government. In all other cases, the state government is the appropriate government. Now, the definition provides that the appropriate government for central public sector undertakings, PSUs, is the central government, even if its shareholding in the PSU falls below 50% post the commencement of the codes. This provision, however, is not there in the wage code. The SS code also provides that in relation to an establishment having departments or branches in more than one state, the appropriate government will be the central government. And under the IR code, for banking companies, the central government would be the appropriate government. Under the IDA, it was only if the banking companies had branches or other establishments in more than one state. So this was just giving you a little bit of idea about how the how common the definitions are between the codes, and as well as sort of bringing out certain subtle differences, key differences in these broad definitions as well. So with this, I move on to the next section, which is to tell you really the unique concepts or new aspects that have been brought about with the labor code coming into force, and to sort of also compare it a little bit with the current regime. So the first topic that I'll cover here is the decriminalization aspect. So this is actually a very positive movement, development. The running theme underlying the new labor codes is that of ensuring compliance and not to really penalize an employer. Currently, under the extant laws, if you see, there is no real gradation of the penalty basis the gravity of the offense, and sometimes even for minor non-compliances like not filing of returns or not maintaining some records, there's an imprisonment sort of attached to it. Though in practice, in reality, people may not be necessarily going to jail for something as minor as this, but the fact is that the laws really provide for it, and it sometimes becomes very difficult, especially when you're advising members of the board, etc., to sort of really guide them through, the possibility of a severe sort of imprisonment, a severe penalty of such sort for non-compliances with the act. So this is a very welcome move. There has been definitely a sort of decriminalization of most of these penalties under the labor codes. For example, under the OSH code, penalties by way of imprisonment is reserved for very serious infractions, such as those leading to death or serious bodily injury or obstruction of authorities in performing their duties. Similarly, under the wage code, imprisonment is limited to instances of repeat offenses only and not in the first instance. So while they have removed imprisonment for as a penalty for many of the non-compliances, what we have seen is that the quantum of the fines, etc., has been increased significantly, with the purpose of course, having a deterrence effect, and to encourage people to comply with the law. So, for example, under the wage code, the current legislations provide for a maximum penalty of 20,000 rupees. However, the amount of fine has been substantially enhanced as for the first offense under the wage code, and the fine can go up to almost 50,000 for the first offense, and for subsequent offenses, the fine can extend up to 1 lakh rupees. Next, there is a concept of now redemption under the labor codes. It allows the employer a framework whereby it can avoid prosecution being initiated against it if it is willing to rectify the wrong that has been committed by it. The inspector cum facilitator is in fact restricted from initiating any action unless the employer has been given an opportunity to rectify the non-compliance with the stipulated period. So, this is, however, employer would be disqualified, of course, from availing an opportunity to rectify it if he subsequently indulges in similar violation within a period of 3 years under the OSH and the SS code, and within a period of 5 years under the wage code. However, such a provision is absent in the IR code. Under the extant legislations, while employers are given an opportunity to be heard before an imposition of penalty, such an opportunity to rectify is not present. So as you can see, there is definitely a shift from trying to impose sanctions for non-compliance to encouraging compliance and to actually helping the employers to be able to rectify these non-compliances. So that's definitely a welcome change and a relief for employers in India today. The next important concept is now that labor codes provide for compounding of offenses. Again, a completely new concept, from a labor law perspective. Employers under the current labor law regime do not actually have that kind of right to compound for offenses under most of the statutes. Employers have the right to seek compounding of offense under the IR code, either before or after an inquiry or prosecution is initiated. Employers will be required to pay a percentage of the maximum penalty at the time of making an application for compounding, and that is prescribed under the relevant codes. Again, there is a new concept, a new role of, I would say, inspector. In fact, the nomenclature itself has changed. There's no longer a nomenclature of inspector, but that has moved to the advisory role of an inspector cum facilitator. The concept is quite novel. Under the current regime, an inspector's job is limited to kind of carrying out inspections and enforcing, compliance, so on and so forth. But under the codes, the inspector cum facilitator is required to supply information, sensitize the employers of their various obligations under the codes. So it's definitely a welcome change from the kind of wrath of Inspector Raj that we've all been kind of sort of facing, and employers have historically faced over these years. But interesting to note that again, the concept of inspector cum facilitator is not present in the IR code. Okay. Then the next important aspect is the exclusion of jurisdiction of civil courts. The IR code specifically excludes the jurisdiction of civil courts in respect of any matter to which the IR code applies, and also provides that no injunction can be granted by a civil court in respect of anything done or intended to be done under the IR code. This is a modification brought about by the IR code, leaving employers and employees with recourse only to approach authorities prescribed under the IR code. This concept has not been specifically not present under the current Industrial Disputes Act. However, this is the understanding as it flows from the judicial precedents. A lot of case law which kind of have taken this view, but now they have specifically enshrined it within the IR code, quite clearly for the benefit of all parties. A similar construct of this nature is also there in the OSH code. Next up. Another key feature of labor codes is that there is a lot of emphasis on digitization. The maintenance of records, registers, filings, etc., all can be done electronically, and that is definitely something that is going to make life a lot easier for employers across the board. There were some forms of it already existing in the current regime, but the practices in relation to all of this kind of differed from jurisdiction to jurisdiction. So to give you an example, if say a state law allowed you to file electronically, etc., there could be a practice of also sending a physical copy, or also ensuring that a physical copy is sent. Or sometimes when there wasn't much clarity on how the officer will treat it, we would usually advise you, please send it in electronic form as well as a physical form. So that was the kind of differences that were there. Now again, there has been an attempt to unify, to make things as same as possible across the board, and the digitization is definitely a step in the right direction. To give you a flavor of the kind of things you can do electronically now, all your records, registers can be maintained electronically, returns can be filed electronically under the code, even the wage slips can be issued in electronic format to the employees. Under the IR code, the filings and registrations of trade unions, certification of standing orders, all of this can be done electronically. So this goes a long way to really promote the ease of doing business in India. And especially now in a post-COVID world where a lot of industries are working from home, etc. Again, this is something that will definitely ease with, will definitely help with, ensuring more and more compliance by the employer. Another interesting concept is the overriding effect. So important to understand that the provisions of the codes will have effect. All of these have specific provisions on this, which say that they'll have effect notwithstanding anything inconsistent contained in any other law for the time being in force. So it basically means that this will override all other laws on similar subjects to the extent of any inconsistency with the other law. However, if any other law, award agreement, contract of service, etc., provides more beneficial terms than the code, then to that extent they will prevail. So that's a similar concept even now. Even today, employers always free to enter into terms of and to provide benefits or terms, etc., which are more favorable than what the law provides. And to that extent, that will supersede what the minimum requirement is under the law. A pertinent point to note is in relation to preservation of actions taken under existing laws. So once these laws, 29 laws, get repealed and get replaced by the current labor codes upon their notification, the corresponding legislations will stand repealed, but any actions taken under those enactments will be deemed to have been done under corresponding provisions of the codes. And they will be enforced to the extent that they are not contrary to the provisions of the codes, or until they are specifically repealed by the central government. Now, exemptions. Some interesting sort of provisions which are there in the IR code, and in particular. So under the IR code, the appropriate government has been vested with the discretionary power to exempt new industrial establishments, new undertakings from all or any of the provisions of the IR code, if deemed necessary in public interest. However, the term public interest has not really been defined under the IR code. Under the IR code, the word new industrial establishment or new undertaking, etc., means those industrial establishments or undertakings which are established within a period as may be specified in the notification. So we are still awaiting notifications, clarity on these aspects, and they'll probably specify a time period for these new undertakings for which duration they may be exempt by the appropriate government on account of public interest. Similar provisions of this sort also exist under the OSH code. Drawing from the experience of the COVID-19 pandemic, the OSH code provides the appropriate government, again, the power to exempt any workplace, work activity, or class thereof from provisions of the OSH code in the event of any public emergency, disaster, or pandemic in the whole or part of the country for a period of up to 1 year. Next, I think, again, very important, the randomization of inspection regime is what is envisaged under the labor codes. The appropriate government is empowered to frame an inspection scheme that may provide for a web-based inspection, web-based information calling for inspection electronically as well as assign duties to carry out such inspection based on random selection. So I think this is quite important because right now inspectors, kind of have their own sort of way of conducting the inspections, etc., which may not be that transparent. But now with a web-based system of inspection and a focus on a randomization of inspection regime, I think this will definitely help with ensuring a lot of transparency with the system, and if properly framed, it could definitely cut down on the abuses and the corruption that are rampant in the inspection regime currently. But again, interesting to note that this concept is not present in the IR code. Next, Social Security Fund. Under the SS code, the SS code envisages setting up of a gig and platform worker social security fund to provide social security and welfare benefits to gig and platform workers. Again, new concepts under the code. The gig and platform workers fund will be set up and administered by the central government and will be funded by a combination of contributions from the central government, state governments, and the scheduled aggregators specified under the SS code. Scheduled aggregators include those involved in inter alia ride sharing services, food and grocery delivery services, content and media services, and e-marketplaces. Under the OSH code, again, Social Security Fund is to be established by the appropriate government for the welfare of unorganized workers. The amounts collected as penalties for certain non-compliances and through compounding of offenses will be utilized for this fund. The appropriate government may prescribe other sources of funding as well. The entire corpus is to be used for welfare of unorganized workers in the manner that will be prescribed by the appropriate government. Last, a little bit on the limitation periods. So again, the limitation periods were differing from, statute to statute. And in fact, many labor legislations don't have any specific limitation periods, but recognizing the need for having a clear limitation period for raising of claims. Again, a lot of these new concepts have been introduced in the in each of the labor codes. The OSH code provides that a court cannot take cognizance of any offense punishable under the code unless a complaint in respect thereof is made within 6 months of the date on which the alleged commission came to the knowledge of the inspector cum facilitator, and a complaint is filed in that regard by him. Under the current sort of Factories Act, DOCW Act, the limitation period is 3 months. Again, under the SS code, like currently the PF Act, for example, doesn't have a limitation period, but the SS code envisages a time period of 5 years as a limitation period under the PF and ESIC regime. Currently, only the ESIC Act prescribes that orders cannot be passed in respect of any period beyond 5 years from the date on which the contributions become payable. Under the IR code, again, IR code expressly bars the conciliation officer from holding any proceeding related to an industrial dispute after 2 years from the date on which the industrial dispute arose. So with this, I kind of, I come to the end of the second section as well, where we were talking about the unique concepts. And now we'll move on to talking to you about the specifics of each of the codes. I will now cover the IR code, and after that, Abe will take over. So the salient features of the IR code. Now, as we discussed, IR code basically subsumes the Industrial Disputes Act, the Trade Unions Act, and the Industrial Establishment Standing Orders Act. There are about 104 sections in this code and spread across 14 chapters and 3 schedules. That's the broad layout. Before we go into the actual provisions, two important definitions which are important to discuss are the worker definition and the industry definition. So the worker definition is very similar to the definition of the workman under IDA, but the terminology has now changed from workman to worker. It specifically excludes apprentices under the Apprentice Act. Earlier, it wasn't coming out very clearly. But now this is quite clear from an IDA perspective that apprentices under Apprentices Act are excluded. It includes two additional categories. One is working journalists under the Working Journalists and Other Newspaper Employees Act, and it also includes Sales Promotion Employees Act. Now, under the current regime, only some states had specifically included sales promotion employees within the workman definition, such as Tamil Nadu, etc. But again, by virtue of the Sales Promotion Employees Act as well, only notified industries, only workmen from notified industries were to be covered. Now, given that this is a part of the worker definition itself, it just basically means that sales and promotion employees in any sector would get covered within the ambit of the worker definition. There is also a change in the threshold, salary limit threshold for exemption of supervisory employees. That has changed from the existing 10,000 to 18,000 rupees per month. And of course, the central government will reserve the right to modify this limit from time to time. So besides that, there is no other kind of material change. The positive impact of this, broadening of this definition is that a lot of, workforce that were perhaps earlier excluded would now get included. So the coverage has included quite a bit, even from a salary point of view for supervisory category. However, besides that, what is I think still unclear is the status of employees who are highly qualified, highly educated, because that's one question that comes up quite regularly. I have a lot of these employees who are very, very skilled, very, they perform very specialized tasks, they're highly educated, the kind of work they do is highly sophisticated. So why should they get covered under workmen? But unfortunately, there's no there's no distinction or no exemption given on the basis of educational qualifications or, super specialization in any area. There are some case laws which have kind of spoken about these aspects, but again, no clear Supreme Court judgment on this point. So this continues to be a bit of a nebulous concept, and as is the position now, it will require a factual analysis of the main key duties and functions of an employer, of an employee, to determine whether or not he would be a worker for the concept for the purposes of the IDA of the IR code. It does seem that the intention is to cover maximum people and not to exclude on these aspects. And again, to point out, the wage ceiling, the wage aspect is only relevant for the supervisory cadre. For the rest of them who are not in the supervisory cadre, it doesn't matter what salary they earn, and they could be earning very high salaries, but they could very well still be included within the ambit of worker. Next, I'd like to speak about industry. Again, the word industry is quite wide even under the existing IDA Act, but now it has been expanded further to bring it in line with the definition which the Supreme Court had given in a landmark judgment of Bangalore water supply case. And in fact, pursuant to that case, an amendment was also introduced in 1982 to the IDA, but that amendment never saw the light of the day. It was never notified as such. The definition provided by the IR code specifically covers any systematic activity carried on by cooperation between employer and employee, whether engaged directly or indirectly, for the production, supply, or distribution of goods or services with a view to satisfy human wants or wishes, not being wants or wishes which are merely spiritual or religious in nature. So if you see, the construct is quite wide, and this would pretty much cover all industries. I mean, there was always a question sometime before this, that if we are a very specific or specialized service industry, for example, whether that will actually get covered within the ambit of the term industry currently under the IDA. But I think all of these questions have now been put to rest, and the fact is that most definitions, most industries would get covered as a default position, because the IR code has very specific exclusions to this definition. The exclusions are institutions owned and managed by organizations wholly or substantially engaged in any charitable, social, or philanthropic service, activities of the appropriate central government relating to sovereign functions, defense research, atomic energy in space, domestic service, and any other activity notified by the central government. So unless you fall within these four, the default position is that you will be industry, and therefore this code would apply to you, and you'd have to adhere to it on all matters covered within this code, including termination, change of service conditions, so on and so forth. With that, let me move on to the next section, which is on retrenchment, layoff, and closure. So by and large, important, see again, the IDA part of the code, the chapters relating to the current IDA are obviously the most important from an employer perspective, because a lot of rights of the employees of workers actually flow from this chapter or this particular statute. Important thing to keep in mind is that the IR code is quite materially similar to the current regime when it comes to matters like retrenchment, layoff, and closure. But there are no major changes to these chapters, and the position as is would continue. The only significant change is that the threshold for those industrial establishments which require the prior permission of the government to be able to retrench or close or lay off, that limit has now changed from 100 to 300. The interesting point about this is that the 2019 bill did not actually have this limit of 300, and so it therefore subsequently got changed from 100 to 300, potentially to again ensure uniformity of this threshold across the country, because several states have already increased their limit from 100 to 300. I think there's about 16 odd states that have already done that. So in a way, they've kind of introduce this uniform change to cover all other states as well, and to ensure that the limit doesn't go below 300. Important again to note that the appropriate government cannot reduce this limit to 300, below 300, but they could increase it and maybe increase it to 400 or 500 as they wish. Just to clarify again, this limit is only relevant for industrial establishments which are defined as mines, factories, and plantations. So if you're a service sector covered under the Shops Act, this is not a relevant provision. No prior permission, etc., was ever required, and the position continues to be the same under the IR code as well. This will, however, benefit a lot of MSME sort of sector employers. From the point of view of the fact that now there is definitely an comparative ease when matters related to retrenchment, layoff, closure, because government approval, prior government permission will not be required. But nonetheless, you still have to follow all other provisions of the IR code. So you'll have to give prior notice or payment in lieu thereof. You'll have to give retrenchment compensation. And you'll have to follow the LIFO, last in first out principle, the rehire principle. All of those broadly remain the same. For all these activities. Another important aspect here is that the appropriate government has the power to now increase this payment of retrenchment compensation. Currently, under the central statute, it's 15 days average pay for every completed year of service or any part thereof in excess of 6 months. So that amount is something that could undergo change in the near future. In fact, certain states have recently already amended and increased some of their limits, but most of them have done so by way of ordinances. So we'll have to check what the current status is. So, for example, Himachal Pradesh has increased it from 15 to 60 days. Goa has increased it from 15 to 45 days. So it will be good to kind of do that check in your state to see if any such enhancement of retrenchment compensation, etc., has been carried out. One additional cost when it comes to retrenchment, etc., is that now employers will have to contribute to what will be known as a worker reskilling fund. Now that's a fund which the appropriate government will set up. So depending on which industry you are, either the central government or the state government will set up that fund. And as an employer, every time you retrench an employee, you will have to make a contribution on behalf for that employee, which will be the 15 days wages, the last drawn wages, which will have to be paid into this fund. And then within 45 days of the retrenchment, I think the appropriate government will then kind of remit this amount into the account of the retrenched employee. This worker reskilling fund is basically, I think, the rationale of this is to provide some additional monetary support to retrenchment workmen for training and reskilling purposes. Yeah, I mean, that's one additional thing which you now may have to keep in mind going forward as an employer. Moving on a little bit on the strikes and lockout construct. Now, strike, as we're all aware, is is a cessation of work essentially, or a concerted refusal by employees to work. Now, this strike definition has been modified, and it now extends, to any concerted casual leave on a given day, which is taken by 50% or more of the workers employed in any particular industry. This is, of course, aimed at dissuading workers from taking any unannounced concerted casual leave with the intention to disrupt the work at the establishment of the employer. Other important thing about strikes and lockout is that, currently under the IDA, a notice of strike needs to be given, or lockout needs to be given only in public utility services. Essentially, industries involved in essential services like supply of maybe fuel, water, electricity, transport, telegraph, telephone services, etc. And this definition keeps getting modified. The appropriate government keeps changing it from time to time. But now that thing has been removed, that concept has been removed. Now in any industry, strikes and lockouts have to be, the prior notice has to be given. In a way, it's balanced because both the obligation lies on both the employees also and on the employer as well when they are kind of taking any such action. And the notice period is, between 14 to 60 days. It can't exceed 60. It can't be lower than 14 days. At least 14 days notice has to be given before employees can go on strike and before an employer can declare a lockout. Moving on, another interesting concept under the IDA, which will now be mandatory, is the setting up of a grievance redressal committee. Now, the IDA already envisages this concept. Industrial establishments employing 20 or more worker or workmen are required for the resolution of disputes arising out of individual grievances. They're required to set up a grievance redressal committee, which will have equal representatives from both the employer and the employee that will look into these grievances. This construct already exists under IDA, but the only difference is that under IDA there's a clause which said that if you already have a grievance redressal committee, then you don't need to set up one specifically under the IDA. So most employers were kind of relying on their own, say grievance redressal policies, and taking the view that this would not apply to us. Also, the penalties for non-compliance under the IDA for this provision not very high. So this is not a very, we've not seen too many employers actually setting up a GRC in compliance with the IDA Act. But now going forward, this is a compulsory construct because no such exemption exists for any of your own private GRC committees. So therefore now compulsorily you will have to set up a GRC which is in compliance with what the requirement is under the IR code. The intention of this does seem to be to kind of give the employees another opportunity for kind of resolving the disputes before it becomes an industrial dispute and it goes outside of the organization for any resolution. But again, individual grievances are not really defined. So we'll have to wait and see what all that will encompass. Very quickly, what are the requirements for setting up the GRC? Representatives of both the employer and the employee are required. The number of members of GRC has been increased from 6 under IDA to 10 under the IR code. Women representation is also now mandatory. The IR code mandates that adequate representation of women workers in the committee should be there, which should not be less than the proportion of women workers as to the entire kind of head count or the total strength of the organization in the industrial establishment. So again, that's a welcome move to kind of have more women representatives on a committee of such nature. There's also a limitation period to sort of raise any grievances, which is 1 year from the date of the cause of action that has arose. GRC is also required to complete the proceedings within a tight timeline of 30 days. And it clarifies that the decision of the committee on the application file before it can be made on the basis of the majority view of the committee, and such that more than half of the members representing the workers on the committee should have agreed to such a decision. So all these aspects have to be kept in mind going forward while setting up a GRC, or also in terms of how they will kind of give their views on matter. Under the IDA, an appeal against the decision of the committee could be made to the employer, But under the IR code, the application against the decision of the committee has to be filed with the conciliation officer. One other important role of the GRC is that in case of any changes in terms of conditions of employment, then just under the IR code, just as the case was with the IDA, any changes in the conditions of service as mentioned in the relevant schedule, if it was kind of affecting the workman negatively, could only be implemented after 21 days notice to the affected workman. So the same concept exists under the IR code, except a few bullets have been added as points of exception to the rule, or where your 21-day notice is not required. One of which is that any changes, employer can make changes to the shift workings due to any emergent situation, which is done with the consultation of GRC. If that is a situation, then the employer need not give the 21-day prior notice and can roll it out immediately. This could benefit, I think, some of the industries where, say, who are working from home, etc. This is something that could be beneficial for them, where if you have the blessing of the GRC, you should be able to implement any change in the shift workings with a little bit more ease than the current construct is under the law. Now, from a trade union perspective, again, the registration of trade union, the concepts broadly remain the same. Another important aspect to cover is that the worker definition under the IR code for the purposes of trade unions includes all persons employed in trade or industry, which is more expansive than the regular worker definition. And it also includes worker as defined under the Unorganized Workers Social Security Act. Now, the IR code has introduced a very interesting concept of a sole negotiating union or council in industrial establishment having registered trade unions. So again, the law on recognition of trade unions has been very different in different jurisdictions, and some states have their own laws, specific statutes helping the employer to understand what how do you determine what is a recognized trade union for the purposes of industrial establishment. But there are several other states that do not have any such legislation, and this is always added to a lot of confusion in terms of how do you determine which is the side of the representative trade union for your establishment. So IR has introduced this concept of a sole negotiating union or council. In case of multiple registered, in case of multiple recognized trade unions, the one with the support of at least 51% of the workers on the master roll of the establishment will be recognized as the sole negotiating council. When there are more than one, if there are two, then the one with the with 51% of the workforce will be taken as the sole negotiating council. And if you do not have, suppose there is also a situation where you do not have any registered trade union which has more than 51% membership, then in that case the employer is obligated to set up a council, and that council will consist of representatives of registered trade unions which have the support of not less than 20% of the total workers on the master roll of that establishment, and each such trade union who has a support of at least 20% of the workers will get one seat on the council. Negotiating union or council will require to negotiate with the employer on such matters as may be prescribed. Currently, the Act and rules don't go into it, but they do play a role in, at least from reading of the IR code, in in certification of standing orders and so on and so forth. Now, a little bit on the dispute resolution. One of the key changes in the IR code is a significant reduction in the number of authorities under the IR code. So there are multiple authorities right now. There are labor courts, there are boards of conciliation, courts of inquiry, tribunals, so on and so forth. So all or many of these concepts have now been disbanded, and the ones that exist are tribunal, national tribunal, in addition to the conciliation officers. Very quickly, the power of the conciliation officer has also been kind of broadened quite a bit, and now they're vested with more powers, which extend to issuance of commissions to examine witnesses and to exercise such other prescribed powers, which are in addition to his already existing power to examine witnesses and produce documents, etc. Moving on. Now I'll cover very quickly the standing orders aspect. Now ISO Act is actually, as you're all aware, applicable to only certain specific industries which fall within the ambit of the Payment of Wages Act, and also notified establishments, the one which are not specifically set out. In addition to that, if there's a notification to this effect by the appropriate government covering your industry, then the Act applies to you. And if you exceed the limit, which is 100 in under centrally, and the limit in certain states has been reduced to 50 and maybe 20 in some cases as well. If you meet the threshold, prescribed threshold, then you are required to kind of take certification for your standing orders, which will apply, which are broadly, I would say, terms of employment agreed between employer and employee. Now, the key difference under the IR code is that given how wide the ambit of industry is, the default position would be that most industries do get covered, and therefore you will have to follow the you will have to have a standing order which applies to your establishment if you cross the threshold which is prescribed. Under the IR code, again, the threshold has been increased, and it has been made 300 from 100, with again a condition that state governments can't reduce it beyond 300. So again, it's an attempt by the legislators to bring about some sort of uniformity in this threshold as well, because again, the law as it stands today currently allows the appropriate government to reduce these limits as well, and therefore there's difference in different states as to A, what industries are covered, and B, what is the threshold for applicability. So all these things have now been streamlined, and now it's very clear that while from an industry perspective you may get covered, the threshold will be 300, only higher. You can prescribe a higher threshold but not a lower threshold. Another important aspect under something which is of which really makes employers' life easier is that the model standing orders which the central government will release, if you are as an employer ready to take it up as is, then you don't need a separate certification. You only need to intimate the authority. So there's this deemed certification concept which can really cut down a lot of compliance in relation to the standing orders aspect. If an employer wants to kind of change the model standing orders, wants to apply some the model standing orders with some differences, then he can apply to the appropriate government with a table setting out the differences, etc., and explaining the reasons for the same, and then the certification process can follow after that. And of course, in case of a modification, you will have to get a certification for the modified standing orders. So this is broadly about the standing orders aspect. Last, the important aspect that I'd like to cover is the fixed term employment. Now, fixed term employment is actually defined under the IR code. This is not a new concept. This has always existed. This was legal, and many industries have been following this concept of fixed term employment. In March 2018, the central government introduced the concept of fixed term employment into the central rules under the Industrial Standing Orders Act. And initially, it was only for the apparel industry, but then it got sort of, it got extended to all kinds of industries. So even today, the position is that fixed term employment is regulated under the current regime. The same concept has also been retained under the IR code. Following the central government amendment, a lot of state governments have also come up with, have amended their respective state rules under the ISO Act to recognize this concept of fixed term employment for certain sectors. The IR code now specifically recognizes fixed term employment in all industries. And the IR code, under the IR code, a fixed term employer is entitled to inter alia the following: payment in wages, parity in wages, working hours, allowances, and other allowances similar to those extended to permanent workers for doing the same work or work of a similar nature. So I think prior to this, the fact is that even though employer and employees would would enter routinely into fixed term employment contracts, there was the bargaining power of the employee was perhaps not that high, and therefore there were situations where there could be room for exploitation. So I think with a view to kind of take care of that, the IR code again is very specific to say that you have to give parity in wages and working hours, allowances, and all other benefits similar to those extended to permanent workers if they are doing the same job or work of a similar nature as a permanent employee. Also, these FTCs will be entitled to all statutory benefits extended to permanent workers, but proportionate to their period of employment. And lastly, the IR code says that you'll also be entitled to gratuity benefit if such fixed term worker renders service for 1 year under the contract. Now, this last one is again there is some there are many questions that are coming as a result of this as to how this would really apply. How will this 1 year concept be looked at? Whether FTCs will get benefits, if they don't complete this 1 year, but in case of accident, death, etc. So a lot of these open points are there, and it has to be read in tandem with the SS code as well. So there are a lot of issues which are yet to be completely resolved. One important clarification in the IR code, which is the last point that I'm going to make here, is that the term retrenchment specifically excludes any sort of expiry of the contract of an FTC on the completion of the period. So basically, that is not considered as retrenchment. However, if you have if there is a termination by an employer prior to the completion of your period, then it could be seen as retrenchment. So again, that would be a fact-specific analysis which would have to be analyzed separately. So broadly, these are the main concepts, the salient features under the IR code that we want to discuss. With this, I come to the end of my section. Now I will request Abe to carry on from here and sort of speak about the salient features of the OSH code as well as the SS code. Over to you, Abe.
Thank you, Richa. Good evening, everyone. I'll be taking you through the salient features of the OSH code, which is the Occupational Safety, Health and Work Conditions 2020, and the Code on Social Security. In short, I'll call it OSH code and SS code. With that, let me start with my session. Just one second. I think yeah. Okay. So these are the important points that I want to cover in my discussion. I'll get on to it now. One is the worker concept. And just to let you know, as you recall, what Richa mentioned was that the OSH subsumed Secretaries Act, Labor Act, and the Sales Promotion Act and the POCW Act. It has given a common definition of worker across these statutes, those 13 statutes under the OSH code, and which is similar to what you have under the other three codes. So what is the worker definition here is similar to what you may have under the IR code, a person who has technical skills, operation skills, similar to what was there also under the IDA, but this is completely different from what you have under the Factories Act, which is what this law is subsuming. So under the Factories Act, you have a worker definition to mean those employees who are earning or who are connected in some manner to the manufacturing process. This OSH code definition of worker takes it away completely from the manufacturing concept. It has, if he satisfies any of those 7 classifications under the OSH code, he would be covered under the worker definition. What this could do is that it can expand on your workforce if you're a factory, and once your OSH code comes into picture, you may have a larger workforce who will be covered under the definition of worker than, say, under the Factories Act. For example, field workers. Under your Factories Act, field workers are not at the site but are connected to are carrying out checks on what is the raw material coming in. They would not have been covered under your Factories Act. But now under the OSH code, these very workers would be covered along with sales promotion employees and the other 7 classifications that are there. That is one important change. The other change that has happened to that worker definition is under your Factories Act, worker definition included third-party employees. This definition of worker under the OSH code does not use that point about third-party workers, which may not really affect the company because there are additional duties on a company, on a principal employer of a factory where contract workers are deployed, and I'll get to that chapter. So that change may not have been much or may not have much of an impact, but just to point out that these are the 2 major differences that have come from the definition of worker. That's one. Second, moving to factory and establishment definition, OSH code covers all types of establishment, whether you're a commercial establishment, IT, ITS sector, or even factory. That's one. Insofar as establishment is concerned, the OSH code will cover an establishment which employs 10 or more workers. That's the threshold, 10 or more workers, or it's a dock or a mine, it will cover. The OSH code will apply to such commercial establishment. And therefore, you will have to, as a commercial establishment employer, you will have to comply with all the provisions of the OSH code. That's one. So far as factory is concerned, there's a two-step two type of thresholds that have been mentioned. One is for registration, and one is for all of the provisions of the OSH code. So when it comes to registration, a factory is defined to mean a place which carries on manufacturing process and which employs 10 or more workers. So irrespective of what, it's not about aid with aid or without aid for registration purpose. The minute a manufacturing process is undertaken by a factory employing 10 or more workers, you need to register. You need to then be aware that registration process will apply to such a factory. For all of the chapters, the factory definition has been changed. The thresholds have been doubled. So under the existing factory definition, the thresholds are 10 or 20. 10 where the manufacturing process is undertaken with 20 where it is undertaken without the aid of power. In some states, they have increased it. But under the OSH code, that has been doubled. Now it's 20 and 40. So if you are a factory undertaking manufacturing process with the aid of power and you have 20 workers, then you are covered under factory definition. If you are doing it without the aid of power and you have 40 workers, then you are not. Then you are treated as factory. Is the way the thresholds have been doubled under the OSH code. Moving to the occupier definition, it is the same. What you find under Factories Act, which is not there perhaps under your shops and establishment, but it is more relevant from a Factories Act perspective, the occupier definition. Under the Factories Act, the occupier definition was anyone who is in ultimate control over the factory. That has been replicated on the OSH code. There is no difference. One difference is insofar as companies are concerned. Both under Factories Act and OSH code, occupier for factory is the of that company. The difference is that for the under the OSH code, independent directors are excluded. So unlike the Factories Act, which has no much demarcation between independent and directors, OSH code excludes independent directors. That's the difference between the OSH code and the Factories Act. Moving to the BOC worker definition and interstate migrant worker definition, concept is same for BOC. Similar definition, somebody who's involved in building and construction. Tools have been changed a bit. Now, the OSH code, all building and construction activity in relation to a factory is excluded. Second, if you're undertaking a project, a residential project for self-use, and the value of it is not more than 50 lakh, unlike the current law, which is 10 lakh, the threshold has gone up, the value threshold has gone up. So up to 50 lakh self-use residential projects are completely excluded. So that's the concept of BOC worker definition that has undergone a change. I'll just remove my video because there's a problem with my internet, it seems. I hope you can see this slide that's on it. So moving to interstate migrant worker. Interstate migrant worker, current law, Interstate Migrant Worker Act covers only those migrant workers who are recruited by contractors. Under the current law, under the OSH code, it will now include direct employees, directly recruited from one state and brought to the other state, called the destination state. They will categorize such an individual as interstate migrant worker. Of course, if his salary is in excess of 18,000 rupees per month or such other notified amount, then he again is excluded. But at least up to 18,000 rupees and monthly earner of to 18,000 rupees will be categorized as interstate migrant worker. There's a whole chapter on what needs to be done. That chapter applies to an establishment which engages such interstate migrant worker in excess of 9 or more. Once you engage such interstate migrant worker of 10 or more in numbers, then the chapter applies to you. What are you supposed to do? You're supposed to give them all the benefits under the EPF Act and ESI Act, whether you're a direct employer or the contractor has to provide. One, second, your working conditions should be suitably modified to take care of their interests, given that they come from one state to the other. There will be rules on what needs to be offered. We'll have to wait and see, but that's the concept that they have covered under the OSH code. And of course, they have the right, the government can frame schemes for portability of their PDS benefit as well as the CES in the BW CES Act. So those are the important elements of the key differences between the Factories Act and the existing law versus what you have under the OSH code. Now moving to the registration and closure chapter. This has again completely changed what you have seen perhaps under your Local Shops and Establishment Act or your Factories Act, the registration concept. Under the OSH code, there is a duty on the employer to register himself within 60 days, whether it's a commercial establishment or a factory. So within 60 days of commencement of business, you do need to register under the OSH code. The exception is that if you are registered already under a central labor law or any other notified law as would be notified by the central government, then you don't need to have a, you do not need to take a separate registration under the OSH code. Registration will suffice. If any change occurs to the details you have provided in your registration, then within the timeline provided under the law, you need to intimate those changes to the authority. Now, why is it so important to register? There is a bar that has been prescribed under the OSH code. The bar is if an employer fails to register, then he will not be entitled to employ anyone in his establishment. So the impact would be not just about penal provisions being triggered against an employer and paying fines for it, which are pretty high under the OSH code, but also severely curtailing your ability to run your business. That will be the twofold impact if you fail to obtain a registration under this OSH code. Okay, so far, if you remember, I had spoken about two-step process. 10 if you purely for a registration purpose, and then 20 and 40. Therefore, as a factory, if you engage 10 or more employees, workers, you are duty bound to obtain a registration. Another positive feature under the OSH code is the introduction of a common license concept. So for a factory, you can register under a common license both as a factory plus for deploying contract labor, or you can obtain a single license. So that avenue is available to an employer, which will be helpful from a compliance perspective. Moving to the contractor, in addition to the common licensing or the single license that I spoke about, a contractor also has two more types of license he can obtain. One is the project-based license that he can obtain from the authority. And if he is executing work across states in more than one state, he can obtain a pan-India license. So these are positive features that the government has introduced under the OSH code. Lastly, on the closure, there is a duty that is cast on the employer to intimate. It's a post facto intimation of closure of that establishment. One important responsibility that has been cast at the time of closure is the duty to certify that all worker dues have been paid. So please be aware that there will be a certification that an employer will have to give to the authorities confirming that all workers have been paid their dues. Now, moving largely there is a lot of flexibility extended to employers, especially those who are dealing with factories. I'll explain this. One, of course, I want to highlight is a beneficial provision on the number of working hours that have been prescribed under the OSH code. It prescribes 8 hours of normal working hours, unlike your Factories Act, which prescribes 9 hours. So from an employer's perspective, this is more beneficial. Why? Because normal working hours have been reduced by 1 hour to 8 hours. Anything done over that will be treated as overtime hours. So under your Factories Act, the regular hours would have been 9. Anything over that would have fetched an employee his overtime wages. Under OSH code, it will be 8 hours, and then anything over that will fetch him his overtime wage. So that's one benefit that has been granted to him. Second, on flexibility itself, so far as overtime is concerned, there is no bar, unlike your Factories Act, which bars overtime hours and you need government approval or chief inspector's approval under Section 65 of the Factories Act. Under the OSH code, there is no such bar. It only stipulates that as an employer, if you want to employ someone on overtime hours, you must obtain his consent. That's the only condition that has been prescribed under the OSH code. So far as overtime work is concerned, then of course the rules will be framed as to the number of overtime hours that an employee can do, plus what is the rest, interval of rest and the spread over. We'll have to see how those rules will be drafted. The expectation would be that the state government will not impose any prohibition under the or regulation or restriction on how an employer can employ people on overtime, except to limit the number of hours perhaps, but nothing more than that is what the expectation is, and we will see how the rules are framed to cover that. Last point on this is the weekly off. like your Factories Act, it prescribes a requirement to provide a weekly off. That is, no employee should work continuously for more than 6 days. The seventh day shall be given as a weekly off. There is no fundamental difference, that is to say, between this OSH code and your Factories Act or the Local Shops and Establishment Act. But a little minor benefit is for the employer is that unlike under the Factories Act, your weekly off, the way it's been drafted, the way it's been defined, will normally be a Sunday, and you need to take approval of the inspector, the chief inspector, to change that. That there is flexibility, therefore, under OSH code compared to your Factories Act when you determine what your weekly off should be. With that, I will move to the other. This is the last slide on OSH code. These are the 4 points I want to cover. Leave provisions completely made more. Let me put it this way: it's more beneficial in a way of speaking for employees. A lot of changes have happened. Rate hasn't changed. Just like and I'm comparing it again to factories, local shops. Perhaps you'll have various versions of it. But from a Factories Act perspective, your OSH code has completely changed what you have been expecting to see, or what you have been used to under the Factories Act. Rate hasn't changed, one for every 20 days work. But what has changed is the right to take leave in that very year. Now, under Factories Act, your entitlement would be for the subsequent year. That's how the Factories Act has defined leave. Perhaps many employers allow employees to take it in that very year, but at least under statute, it mentioned that you have to take it in the subsequent year. What the OSH code has done is it prescribes that the leave accrued can be taken in that very year. So that's one change. Second change is to your qualification period compared to Factories Act. Under Factories Act, an employee who joins a company will only be entitled to the 1 to 20 days, one for every 20 days work, if he has worked for the company for at least 240 days. That qualifying period has been reduced to 180 days under the OSH code. The second qualifying period is for those employees who join after January 1. The Factories Act requires him to have worked at least for 2/3 of the remainder of the calendar days of that year. The OSH code has reduced that 2/3 to 1/4. So again, as I said, it's more beneficial from an employee side, and as an employee, you should be aware of it when your HR teams are dealing with your leave provisions. Once the OSH code comes into picture, leave carry forward, no change. It's still 30 days. Leave encashment, no change. It can be encashed at the time of your cessation of employment. But one additional right that they've granted to employees is the right to encash at the end of each calendar year. You will not have found this provision under your Factories Act, and perhaps also under a lot of Shops and Establishment Act. But under the OSH code, employees do have a right to now seek leave encashment at the end of each calendar year. So it's a added benefit that has come onto to the employees. The other change that has happened is, as I explained, or leave encashment, otherwise leave carry forward, remains the same. And these benefits will accrue once the OSH code comes into force. Now, moving to special provisions on employment of women. As you may be aware, especially under the Factories Act regime, there was a restriction on employing women. Female employees could not have worked during the night time. General restriction was for time before 6 a.m. and after 7 p.m. And with approval, that could have been allowed. But again, there was a complete ban on employing female employees before 5 a.m. and after 10 p.m. Now, what has happened under the OSH code is that it has completely removed those restrictions. Now, under the OSH code, a female employee can work during nighttime. There is no restriction. There is no prohibition. What they have done under the OSH code is move the obligation onto the employer. Twofold obligation on the employer if he wishes to employ female employees at night. One is obtain their consent. There is a duty cast on the employer to obtain consent, which means as an employer, as your HR team, as a lawyer or legal in-house counsel, you should be looking at your contracts to see if should you be looking at engaging female employees. Does your contract provide robust terms? Have you obtained? Is there consent terms that have been recorded for you to then deploy them at night? That's one obligation. Second obligation is that the appropriate government will come out with rules on what are the working conditions that you'll have to follow, safety measures that you'll have to follow, benefits that you'll have to follow, which you'll have to, as an employer, comply if you wish to engage female employees at night. Now, coming to the other important change that has happened to the contract labor concept is that, one, the definition has completely changed that Richa spoke about. It's more about those who are specifically hired for the work of an establishment as opposed to regular employees who are receiving their benefits, their incentives, their salary on terms that have been mutually accepted. Those type of employees, regular employees, will be excluded, permanent regular employees will be excluded, and those who are specifically engaged for a project of the establishment principal employer are the only ones who are supposed to be covered now under the OSH code. So that's one change. Second is that, therefore, for example, if you're dealing with IT outsourced work, under CLRA, there have been question marks on it, and perhaps you are covered, that kind of arrangement is covered. Under the OSH code, it should clearly be excluded, provided the general understanding is that regular employees are deployed at the client side. And if those features exist, then in future, once the OSH code comes in, you will not be duty bound to cover them under the contract labor chapter. Second important change is the threshold. Current law is 20. Now it has been increased to 50. So if you have 50 or more, then only would this chapter apply. What happens if it applies is there are some duties cast on the principal employer. Unlike CLRA, that's Contract Labor Registration Act, where the liability is vicarious. Only if the contractor fails would you be liable to provide those benefits. Under the OSH code, that vicarious liability is only restricted to wage payment. So if the wage is not paid, then you are vicariously liable. Otherwise, it's contractor's duty to pay. But for all other benefits, welfare measures, it would be the duty of the principal employer to provide for all that. The law does not recognize the concept that you've seen under CLRA, where the contract provides benefits, and on a failure does the principal employer step in. That concept has been completely removed. Now it's the principal employer who has to take it, who has to provide for it, and therefore, you need to make sure your contracts are properly drafted to cover for any cost that you will accrue for providing this, because again, under the OSH code, they do not provide for any recouping of these costs. So it's very important you look into your contract to make sure you have sufficiently protected yourself. There are then the last point on core sector prohibition. It completely prohibits deployment of contract labor in core activity, basically activity for which you are set up. There are exclusions provided such as support services, housekeeping services, transportation, canteen services. You can still go ahead and deploy. It's not core sector. Lastly, even for core sector, you can seek the exemption from the authorities by showing that this work is typically done by contractors, or that you do not generally employ permanent employees to do that, or that there's a sudden spurt in the volume of work, and thus you need the exemption to then deploy contract labor. So there's a lot of flexibility offered to employers. Just have to make sure your reasons are justifiable for you to obtain such an exemption. Duties of employer, quite a few duties. One is based on rules that will come out under for the safety and welfare measures and working conditions that will be applicable to all employees. Second duty is to provide written agreement to all employees. This is not there under your regular law, under the Factories Act or the Local Shops and Establishment Act, subject to any rules that may have been framed by some states. But otherwise, there was no duty to provide for any written agreements. Now, under this law, you are duty bound to provide written agreements. Third element is the protection to transgender employees. You'll have to provide separate facilities such as bathroom, restrooms, locker rooms for even transgender employees. With that, I will conclude my session on the OSH code. I will move to the SS code. SS code, if you recall, what Richa mentioned, was that it subsumes quite a few benefit-oriented laws such as EPF, ESI, as well as your gratuity, maternity benefit. So about 9 central laws have been subsumed by the SS code, and there are about 164 sections that this law deals with. These are the important points that I want to cover right now in the session for SS code. One is on the applicability to establishments. Given that so many benefits have been subsumed under one head under the SS code, the applicability keeps differing. So as an employer, it is important that you are aware of your of the thresholds for the law to kick in or the benefits to kick in. And therefore, I'll just go through each benefit that are covered under the SS code and their applicability to the establishment. Coming to EPF chapter, it applies to all establishments and factories which employ 20 or more workers, 20 or more employees, similar to what you have under the EPF Act. Employee definition includes all employees for the purpose of Provident Fund scheme are to be covered under the Provident Fund scheme. But for the other two schemes, that is the pension scheme and the EDLI scheme, it will only apply to employees who earn up to the notified wages. Now, there's a voluntary coverage recognized under the EPF chapter, similar to what you had, and you can then deregister under this act, and the authority can then impose some conditions if you're seeking deregistration post your voluntary registration. Chapter, complete change. It applies to all establishments that employ 10 or more. Under the current law, there's a number of changes between 10 or 20, but under the SS code, it applies to all establishments which employ 10 or more employees. However, if you're a notified industry carrying out hazardous work or life-threatening work, then even one employee will trigger the applicability of the ESI chapter to such establishment. When it comes to employees, it only applies to employees who earn up to a notified figure. That notified wage as will be notified by the central government. We'll wait and see what that notification is. Under the current law, it's 21,000. So perhaps they may replicate the current situation under the OSH code, but we have to wait and see. But for the however, notwithstanding these thresholds for salary threshold, all employees still have to be counted when you are checking the applicability to your establishment, whether you have 10 or more. For that, you need to count all employees, and you will not then exclude people whose salary is above that threshold. So now moving to the other two benefits, that is the gratuity and maternity benefit. It applies to all factories which employ 10 or 20 employees with aid or without aid. That's one. Secondly, to all establishments which are not factories which employ 10 or more employees. So that's the difference. For a factory, 10 or 20 employee strength that will trigger the threshold, and for all other establishments, it is 10 or more employees. ECA, that is the compensation chapter, will apply to establishments which are not covered under the ESI. So if you're covered under the ESI, your ECA chapter, the compensation chapter, employees compensation chapter will not apply. And if you're not covered, then it will of course apply. It will apply to employees who are whose names are stipulated, or whose details are stipulated under schedule, which are very broad. For example, manufacturing process, if anybody is involved in transportation services, or because of state regulations which list out additional employee details, employee job profiles, those employees too will be captured. Lastly, when it comes to central government or state government, they can add to that list. So the authorities are empowered to enlarge upon the types of employees who could be covered under the Schedule 2. So do remember that. And the OCW applies to establishments which engage 10 or more building and other construction workers. Employee definition is also important. Unlike your current law under the payment of gratuity, which does not include third-party employees, under your SS code, even direct as well as indirect employees, that is through contractors, are deemed to be employees of the principal employer, and you are duty bound to ensure payment of gratuity would have to be made not only to your direct employees but also to your indirect employees. This is because of the way employee definition has been drafted into the SS code. Now moving to the registration concept, similar to what you have under the OSH code, there is a requirement to register under the SS code, but you do not need to register if you have registered yourself under any other central labor law, including OSH code. Now I'll move to the Provident Fund benefits. One common running theme across the SS code is all of these benefits have been more or less replicated. So there are not many changes that have happened to what you find under your Provident Fund law, under gratuity law, under maternity benefit. They're mostly been replicated. So that's one aspect that you please do consider. Now, specifically on Provident Fund benefits, the three schemes, that is the Provident Fund scheme, the EDLI scheme, that is the deposit-linked insurance scheme, and the pension scheme, will be drafted by the central government and will come into force once it is drafted. And until then, for a period of 1 year, all the existing three schemes will continue to apply to establishments. That is one. Second, so far as the quantum of contributions are concerned, the law, the OSH code, similar to what you have under the EPF Act, recognizes the rate to be either 10% or 12% as notified by the central government. When it comes to the pension scheme, it's similar to what you have under the pension scheme or the existing pension scheme. It's 8.33% of a notified salary, which we'll have to wait and see what that notified salary would look like. So 8.33% of the monthly notified salary will be taken out of the employer's contribution and diverted into the pension scheme. Not much of a difference between the existing law and the proposed OSH code, or the OSH code rates that have been defined under the OSH code. Lastly, on the EDLI, it will be 1% or of the wages or amount plus 1/4 of that contribution, which will have to be paid by the employer. So these are the major points under the Provident Fund scheme. Coming to gratuity, as I said, not much of a change. The one thing that they've included is a fixed term employee. So when it comes to qualifying period, just like the existing law, you will only receive gratuity if you have been there for 5 years or more. That 5-year period will not apply if, because of death, if an employee dies or his employment ceases due to disablement, or if there is expiry of fixed term employment. In which case they will be entitled to pro rata gratuity. So it's a new insertion that they have made to the OSH code, introducing the fixed term employment concept. The other change that they have done is the cap on gratuity that will be as notified. So it's not installed or it's not provided in the gratuity chapter. It will be as notified by the central government. So perhaps the existing caps will continue to apply to the employers if the government thinks fit, but we'll have to wait and see what that cap would be. Moving on, otherwise all your registration process, your 30 days requirement to pay gratuity, forfeiture, simple interest if you fail to pay, all of those aspects continue to be replicated under the OSH code. Similarly, under maternity benefit, all the benefits that you're used to, accustomed to under the Maternity Benefit Act have been replicated, whether that's 26 weeks of maternity leave for the first 2 surviving children, and thereafter it goes down to 12 weeks, all the illness-related leave, your medical intervention based leave, work from home concept, all have been replicated. What they have done though, they have improved upon the creche facility concept. And under the OSH code, they have amply made it clear that an employer can take such facility provided for either by the central government, state government, municipality, or any other organization that is providing services. So there is quite a bit of clarity on where you can, from whom you can avail this facility, and the employers can also pool in their resources to create that facility for themselves. So that's a very interesting or very positive development under the OSH code. Then of course your bonuses may go up because a medical bonus will be as notified by the central government. But all other aspects, the restrictions on terminating a female employee under the Maternity Benefit Act have been replicated. So those aspects are not really different from what you have on the existing. The last, yeah, just one second. So this is on employee insurance and the Compensation Act. It's a compensation chapter. It's similar to what you have seen. One second. Okay, can you see? Okay. Yeah, it's similar to again what you have. Your ESI, the rate that you have to pay for your ESI contribution will be as declared under the regulation. The types of benefits, sickness benefit, disability benefit, maternity benefit for people who are covered under the employee state insurance chapter will be as defined under the regulation. So we'll again wait and see what comes out by the central government. When it comes to employees compensation and the ESI chapter, both recognize notional extension. So if you're traveling from your home to your work or vice versa, and you meet with an accident, under both chapters, it is treated as an employment injury, which is similar to what you have under the existing law, replicated. No difference there. Compensation is to be paid to employees under the employees compensation chapter. No big difference. It's a percentage of your salary multiplied by relevant factor under the schedule or such other notified figure, which will be provided by the central government, whichever is higher. So those aspects haven't undergone much of a change. It's what you have seen under the ECA that has been replicated. Funeral expenses have gone up. You need to reimburse the funeral expenses plus medical expenses that the employee has borne for his injury. Coming to cess payment, it's similar to what you have again under the Cess Act. It will be in the range of 1 to 2% of your cost of construction, as again notified by the central government. Cost of construction, clearly they have excluded cost of land and any other compensation payable to the employees. So under both scenarios, which is again under the similar to what you have under the cess fund, all your cost of construction concept is similar. They have also replicated the employment information monitoring system, which is nothing but your employment exchange law, where you need to intimate your vacancies, which again you will have to do under the SS code. The only difference is the applicability has been the exclusion has been reduced. Now under the existing law, that law applied to all private establishments which employed 25 employees and more. Under the SS code, that requirement to intimate your vacancies will not apply if you're an establishment and have only up to 20 employees. So anything over that, you'll have to comply with the vacancy reporting. Misuse of benefits are there. So if as an employer, as any person who enjoys any benefits under the SS code from the government, if he misuses it, the government has a right to stop providing these benefits, which was only there under the ESI Act, now has been replicated for all the benefit sections that are there under the SS code. You still have under the SS code the liability at the time of transfer of assets. So if you're transferring a business under PF law and ESI law, both the transferor and transferee were equally liable to pay for any default. Now this has been extended to all benefits, whether it's maternity benefit, gratuity, EPF, ESI, employees compensation under the SS code. If you're transferring your business, and as a transferee, if you're acquiring a business, both of you will be equally liable up to the value of the asset, no doubt, for the transferee for such defaults. So with that, I end my session. Happy to take any questions that you have on any of these codes that we dealt under this during the session. Please feel free to take it up. We can take it up now.
Thank you, Abe. May I request all the participants to please type in your questions in the chat box. We will answer one by one. Participants, you may type in your questions in the chat box so that it can be answered.
I think Rahul has raised his hand. Please go ahead, Rahul. Or do you want to type in your question in the chat box?
You may unmute yourself. Mr. Rahul Pradhan, you may unmute yourself and ask a question.
Hello.
Hello.
Actually, I want to know what are the impact on that minimum number of for canteens, then factory inspectors and labor welfare, safety officers. That are also get changed, no?
So when you say that regarding factory inspector, what exactly is your question, Ron? I did not follow the question. You just
I want to know what are the like for example, right now there are 500 employees are required and 150 employees are if 150 employees are there, then we require a canteen. So I'm asking about that. That numbers are reduced, no?
They have been reduced. You're right. So quite a few threshold numbers have been reduced under the OSH code, say canteen facility, your restroom facility. So compared to what you have under the Factories Act, the compliance will go up to an extent because of the reduction in the threshold.
Okay.
And you still have to comply, and there'll be rules also around what type of sanitation protection you will have to provide, your restroom lockers under the OSH code. The central government is to come out with these safety and measures, but at the very least, what has been reflected in the OSH code, the thresholds that are there for canteen, for example, or ambulance room, they have, or ambulance room is a new one, but otherwise the thresholds, the concept is that these have all come down
They
compared to.
have reduced 50% or it remained the same or little bit reduced.
So I think under the Factories Act, one second, I'll tell you. Uh, so it used to be 250 or 500, it's been reduced to 150. That's my understanding.
Yeah, almost 50% they had reduced for all that safety, then OSC and canteen in three.
Okay, sure, that's great.
Hello.
Yes, carry on.
Yeah. Is there an option to follow new codes or continue to follow existing laws when it will be
Right.
applicable?
Okay, so just to be clear on this, the all the four codes are not enforced yet. They have received presidential assent, no doubt, but the law, all the four codes require the central government to come out with a notification. So until that happens, codes are not in force. Once the codes apply, as an employer, you do not have a choice. You need to follow those codes, except perhaps to the extent of any beneficial provision that might be there, say in your local shops and establishment act. To that extent, perhaps you may still have to follow the local shops and establishment act, but very clearly those four codes will trump over the laws that they are subsuming.
Hello.
Hello, sir.
Sir. Hello. Good evening, sir.
Hi, yes, please go ahead. Go ahead. We can hear you.
My question is regarding the overtime. As now it has been changed to 8 hours of working hours. So, if suppose after 8 hours, all those hours will be considered as overtime. Hello.
Yes, so that's right. So, under your OSH code, anything over 8 hours will be treated as overtime. Compared to Factories Act, it used to be 9 hours. In some local shops, it's still 9 hours. But when it comes to the OSH code, it's just 8 hours. So anything over 8 hours will be treated as overtime hours.
Sir, good evening. This is Vijendra from GSFC Vadodara. Hello.
Good evening. Vijendra,
I
carry
have a
on.
little confusion about the gratuity portion, wherein what we have understood is the gratuity that is proportionate is only applicable for the FTEs only, like those who are regular on-roll employees. For them 5 years mandatory criteria shall apply. That
Yeah.
is a
That is right. That is right. It's only for FTEs. It's only for fixed-term employees and those who have died in harness that pro rata applies.
okay. Thank you, sir.
Hello, sir. Sir, just adding to my question. Sir, suppose. Hello.
We can hear you, sir. Carry on.
Suppose if we complete 8 hours, you said ki whatsoever adding to that will add to an overtime. Suppose if a worker is goes to work for 8:30 and he returns 5:30, that is 9 hours of working, right? If he added to 5:30 plus 2, that will add it to 7:30. So his overtime will be calculated of 3 hours, or including that rest hour of 1 hour will be calculated. Is it necessary to calculate that 1 hour or excluded that 1 hour?
Okay, so just to clarify on the, since you brought up the interval of rest point, under the OSH code, they have not provided any hours of interval rest. The way I look at it, and of course, let the rules come out, the way I look at it, all the OSH code is trying to say is you can make someone work for 8 hours without paying overtime. So 8 hours would be your regular work. Interval of rest over and above the 8 hours. So if by chance the rules come out, in simple words, say that an employee shall get after 5 hours a half an hour break, that half an hour will not be included in the 8 hours. 8 hours is pure work. Anything over that for interval of rest will be interval of rest. There's no overtime for that. If somebody is made to work beyond the interval of rest and the 8 hours, each hour or portion of it will be considered as overtime hour.
Sir, again, that 48 hours in a week concept will not be there.
So that's the thing, Manoj. The OSH code only talks about daily hours. It does not get into weekly hours. So perhaps again, the rules have to come out, have to be drafted to understand if there are limits on the weekly hours. Now, if there are no limits prescribed for weekly hours, then it will be purely 8 hours. So every day you will count your number of regular hours, and based on that, anything over that you will pay overtime. So if a gentleman works for 8 hours plus another 1 hour, that day's 1 hour will be treated as overtime, and there may not be any limit per se on the weekly hours. But again, as I please do remember, overtime hours, the law requires, the OSH code requires the state government to come out with rules on the maximum overtime. So there would be limits on overtime itself. So they may not say, they may have it in quarter, they may have it in a week. So once your overtime limits are prescribed, then anything over that will not be permissible, because there's a concept of spread over also. So spread over interval of rest and overtime hours will be as defined in the rules. So there will be checks and balance on how much you can make a person work. But those up to those limits, you obviously as an employer, your employee can work for you. But beyond that, it may be impermissible.
Sir, so that if in consideration with the spread over, so we have to take into consideration the inclusion of interval hours also, right?
That's right.
Spread hour. Okay.
That's
okay,
right.
Sir.
Yes, Mr. Sanjay Trivedi, you can speak. Any further questions?
Yes, sir. Good evening. Thank you for the wonderful, extensive coverage which you did so wonderfully. So my question is, by what time will it be implemented? Maybe you had covered it, but somehow missed it. Maybe by what time is it going to be implemented? Actually.
Yeah, let me answer this question. Again, the answer to this question is that we don't know. In terms of implementation, see, the thing is that there are newspaper reports which suggest that this could be brought into force as early as April 2021. But of course, that's not necessarily credible information. State governments and have to also sort of draft their own rules, etc. And right now the central government is busy drafting rules. Like I said, for the IR code, the draft rules have been released for stakeholder comments, and now for the SS code and the OSH code, all of this is awaited. So realistically speaking, once these draft rules are in place, the stakeholder comments usually invited for about 45 odd days. After that, only it's possible for them to notify the code along with the central rules. And of course, we have to wait for the state rules also to be framed and notified, and that will also take its own course of time because there's so many of these states, and they will also individually come up with their own rules under the code, and so on and so forth. Suppose the central government does notify the code along with the rules, then that will become the law, and you will have to comply with it, even if the state rules, say as a private sector, the appropriate government for you is the state government. The absence of the state government rules will not mean that the codes do not apply to you. So that's just one important point to keep in mind, that once the central codes come into force, that will apply, that will repeal the other acts. And to the extent that you will continue to, you will comply, you will have to comply with the requirement. and anything that has been, whatever is under the current construct, so long as it's not inconsistent with the provisions of the code, you will have to comply, you have to continue the compliance with the provisions of the code.
Thank you very much.
Hello. Hello.
Yes, sir, please go ahead.
Yeah, actually, I have a question related to OSH. That it says that the free health checkup once a year by the employer for workers which are more than a certain age. So I want to know about that certain age, and actually, in present we are also doing that on a every 6 monthly basis. So why they are mentioning for a yearly basis for certain age?
That will be again how the rules will come out will explain is there any other facets to this medical examination in a year on an annual basis. But that's at least the minimum that the law expects an employer to do if that's all they will prescribe. But as an employer, you do have a right to extend more beneficial terms. Perhaps as you were suggesting, your annual or your medical checks are much more frequent than what the law prescribes. Nothing wrong with that, and that you can continue your practice.
Yeah. Thank you.
So, hello.
Yes, Manoj.
Yeah. To refer this further, is any website or some details is available on the government or any other portal? To study the
Uh,
things in detail.
okay, are you asking about details regarding the labor codes or about the welfare measures, Manoj?
All the labor codes, what are codes are generated, see the details of the codes.
Yeah, so those codes will be available on the PRS website with the statements explaining each of the clauses. So if you want to get a copy of it, you can surely look at the PRS website. There's a Parliament group that they have that they maintain these codes, the laws that are in force that should give you the source material as well as explanation of each of these sections.
Hello.
Go
Hello.
ahead.
Sir, this gratuity for fixed term employees is for minimum 1 year they have to work, right? And for regular employees, it's 5 years. So
That's right.
my question was that if you are taking some employee on FTE of around 25,000 or 20,000 rupees per month or on consultant basis, then what basic should be fixed for that person?
Okay, so one, just want to clarify, genuine consultants will not be treated as employees. So if you have consultant, like I'm an advocate, I would be consultant to many companies. I will never be treated as an employee. But if as an establishment, it's a subterfuge. We have employees, but they're called consultants. But then the law will look through the relationship and consider them to be employees, and they will have all rights just like any other permanent employees. So that's one. Coming to fixed term employees. The wage concept has been very clearly defined under all codes. So if you remember, Richa had explained this point about how the wages are to be dealt with. So even for gratuity purpose under the SS code, same principles will apply. If you're in simple way, if your basic is going to be less than 50% of all others, by law, those other allowances to the amount that is in excess of 50% of a basic will get added back to your basic. So to that extent, all those components up to 50% is the thumb rule mostly you should be looking at following to ensure that you're in compliance with the law.
Mr. Sanjeev Trivedi, you may please ask the question.
Hello. Hello.
Yes, Mr. Pense, please go ahead.
Sir, can you throw some light on annual leave wages? regarding the one third.
Right. So under the OSH code, I'm talking about OSH code, not the Factories Act or the local shops. Those will differ. Under the OSH code, an employee and a worker is entitled to leave one leave for every 20 days work. So that comes to about 18 days. 365 divided by 20 is 18.25. So 18 days is what your entitlement as a worker would be. Under the worker under the OSH code, that's your entitlement one. Your qualifying period has been prescribed. You need to be working for your establishment for at least 180 days under your OSH code to get that right to seek leave. So the qualification period compared to Factories Act has been brought down considerably. Now it's 180 days. So if you have worked for 180 days, then you are entitled to accrue leave and also can take leave in that very year. You can carry forward unavailed leave to the next year up to 30 days. So that's what the law says, even under Factories Act, and most of the local shops also provide for carry forward or accumulation. So they have replicated it under the OSH code.
Sir, what is the two third of completion of time?
So
Two third or one third?
yes. So what happened was under the Factories Act, and I'll explain it under the OSH code itself. They have used two terms. One is if an employee works for a company, he has to. That is, an employee joins on Jan 1st, then his entitlement to the leave is if he's been there for 240 days. But if an employee joins after Jan 1, the qualifying period is completely different. It used to be under Factories Act two-thirds of the calendar year. So just take any example. If you joined on June 1st, you will be entitled to leave provided you work for two-thirds of the remaining calendar years. That two-thirds has been brought down under OSH code to 1/4. So if you joined on June 1st, even to understand whether you on June 1st, June 2nd, June 3rd, you won't be entitled to leave. You'll only be entitled to accrue leave after you have completed 1/4 of the remaining calendar year days of that year.
Okay, sir. Thank you so much. Okay, sir. Thank you.
Any more
Prema, can
questions?
we wrap up? Yeah. Okay. So if there are no more questions, Premal, can we wind up the session?
I guess there is one question coming up. One gentleman is trying to reach out. He's facing some technical issue. So we'll just wait for another 20 seconds.
Premal, is he in a position to communicate the question to you? Perhaps not here because of the issue that he's facing. Then you can let us know what that question is.
Yeah, I guess we'll take it offline.
Okay, sure.
So that brings us to the towards the close of this session today, and I would really take this honor to conclude the vote of thanks. We had this wonderful webinar on decoding. It's termed as decoding because it's a lot of information, and we need to decode. We need to understand. So our esteemed guest speakers for today, Ms. Richa Mohanty Rao and Mr. Abe Abraham, both are partners at Cyril Amarchand Mangaldas. The esteemed participants, ladies and gentlemen, on behalf of FGI and on my own behalf, I'm extremely thankful to propose a hearty vote of thanks to Ms. Mohanty and Mr. Abraham for excellently addressing on decoding the new labor codes. And also they interacted really well with the participants, answering their queries in a crystal clear form raised by them to their satisfaction. I'm sure our guest speakers have imparted awareness on the codes, making participants compliance ready to understand the changes brought in the provisions of the previous labor codes and how they will impact the organizations. This will also help them for easier adaptation and effective enforcement by the stakeholders with transparency accountability, and be able to undergo a smooth transition. I take this opportunity to express thanks to all participants for making this program a grand success. May I now request everyone to rise up for the national anthem, please.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you, everyone. Thank you for joining us. It was a wonderful interaction. Thank you, participants, and thank you once again, Richa and Abe. This was a wonderful session. Thank you so much.
Thank you so much to FGI and to Premal. Thanks a lot for this opportunity. And we hope to continue our collaboration as it has been going on so far. Thanks a lot again.
Absolutely. Thank you.
Thank you, Richa and Eb, for your wonderful session.
Thank you, sir. Thank you, sir. Pleasure is all ours. Thank you. Okay, thank you. Goodbye.
See you. Bye-bye.